How to use patents when you're negotiating with big ass companies. Watch this video. Okay, everybody, this is Stephen Key, and today we're going to talk about one of the tools that you're going to need when you're negotiating with big ass companies. And it's all about design patents. I love design patents. Now, you have to realize they are affordable, they're easy to do, but they don't do everything that you need. I believe you need to build a wall of intellectual property, and in that wall of intellectual property, design patents is something you need to know about. I use design patents because I love them. They're easy to do, they're affordable, and I can tell you, they're just one brick in the wall of that wall of intellectual property that you're going to need when you're negotiating with big ass companies. So how do I use design patents when I'm dealing with these big ass companies? Well, first of all, in this series, we're going to talk about just design patents, because later I'm going to talk about patents, utility patents, non-provisional patent applications, because I use them as well. But I use them in tandem. I use them together. I like to file on intellectual property on how something's made. But what I like to do is, what does that product look like after it's being manufactured? And that's when I file design patents. Okay, so now we're going to talk about design patents, and I'm going to bring on someone that I personally work with, Kevin Prince. He's a patent agent, and he's going to talk all about design patents. We have Kevin Prince. He's a patent agent. And I also want to say a couple things about Kevin before we get started, because we do have a lot of stuff to cover tonight. I've been filing intellectual property, since, I don't know, the 90s, I guess. Early 90s, and I've worked with a lot of different size firms. I've worked with big law firms, small law firms. I've worked with patent agents like Kevin, but I can tell you, it doesn't matter the size. It really matters if you're going to get good intellectual property. It really depends on the person you're working with. It depends on the person that really cares. And I can tell you, my relationship with Kevin goes back probably 20 years. He was a president of an inventing group in Orange County. So he is a personal inventor. And he does my stuff along with a team of us at Fishbone, which are getting patents right and left now. And he does a fantastic job. So he really watches our back. And that's the type of person you want that you're going to be working with, no matter if it's Kevin or somebody else in the industry. You want to find someone that really cares about you. And Kevin is one of those individuals. Kevin's also told me that out of all the people, all the patent agents, or the patent agents or just patent practitioners?
Just law firms across the country.
Okay. He's ranked number 9 of getting design patents.
Yeah, for the last 12 years or so.
Number 9. And there's a lot of patent agents out there, and there's a lot of patent attorneys out there. So that's a great accomplishment. Thank you for mentioning that. Congratulations, Kevin, for getting such a prestigious award for that. Yeah.
Well, thanks. And thanks for the intro. And, I like design patents. So I market towards design patents. And I'm glad that's the topic today, because there's a lot of confusion about design patents, and so hopefully we'll clear all that up. Wonderful. In the next 30 minutes or so.
I want to explain a little bit how I use them real quick, and then we'll jump into this presentation. I like design patents a lot. They're affordable, they're easy to do, but they're just, in my opinion, one piece of everything you should do. And that's why I really like them, because you know what it does? It allows you to build kind of this wall of IP. It could be utility patents, it could be design patents, it could be trademarks, it could be copyrights. But for me, when I start to protect something that's really important to me, I always include design patents. To me, it's the 1-2 punch, right? It's how maybe something's manufactured, maybe some of the utility, but it's also how it looks. So I really like that very much. One thing I do want to mention real quick, we're going to do something very special at 1:45 the hour, but I'll talk about it a little bit later. So Kevin, go ahead. Let's hear all about design patents.
All right, well, thank you, Stephen. Welcome, everyone. As Stephen mentioned, I am an inventor myself. That's how I got into this business. And there are actually three types of patents, generally speaking. There's utility patents, design patents, and plant patents. And you can forget about plant patents. I think I've seen one, in 20 years. So the two basic types of patents are design patents and utility patents. And really, when people are talking about patents in general, what they mean is utility patents. Utility patents protect how something works versus a design patent, which protects just the way it looks, regardless of how it works. So design patents do not get into what kind of materials are being used, how those are connected together, how the thing operates. It's really just about what they call the ornamental appearance. And so generally speaking, you would say, well, they're not as strong as utility patents. That's probably right. But it's kind of like saying, men are stronger than women, right? I've seen some pretty weak men and some pretty strong women. So there are ways to make design patents stronger, especially with some of the court cases that have come out recently. So we'll get into it. I want to show really my example that I use for kind of highlighting what the differences are, and that is with spectacles or sunglasses. Now, if you look at the spectacles here, that has a particular look, right? But they work the same way as every other pair of glasses. And so for something like that, you've got to have a design patent. In fact, you probably couldn't get a utility patent on that because it works the same way as the standard spectacles or sunglasses. Compare that with polarized lenses, which is the example on the bottom right. For polarized lenses, what you want to protect there is how it works. And so for that, you would need a utility patent. You don't really care if you have invented polarized lenses. You don't really care what the competitors' products look like. If they're using polarized lenses, you want to be able to go after them. And so that's kind of the difference. And they are not mutually exclusive either. I've gotten both utility and design patents for the same product. They just protect different aspects of the invention. So let's look at one of these design patents. This is a bag holder for the plastic grocery bags that you get so that you can carry 20 of them at a time. And this is a design patent, and it's a design patent because it starts with the letter D, the patent number up here. I don't know, can you guys see my mouse moving up there on that? Okay, good. The letter D is the big tip-off that's a design patent. The other thing that you'll notice is that these drawings don't have any numerical callouts. So I'll show you what that looks like in a second. And by the way, when you're looking at a patent, the front page of a patent number is here, the issue date is up here on the right, and then you can look at the title and the inventor. If there's an assignment, in other words, if the patent is owned by a company, that'll be on the front page. And this text right here, that's about it on a design patent. We don't have a lot of text that goes into materials or how it's used or how it's put together, different options. This is really just about the drawings, and the text is a description of the drawings. So what you're looking at there on that one page is a complete design patent. That's it. Now compare that with a utility patent on the same thing. This is a utility patent on the same product, and there's a lot of text, right? We have some drawings, which I'll show you a little bit enlarged so you can see the more detail, but there's a lot of extra stuff that goes into a utility patent. That's why utility patents are more expensive to prepare, because they take longer. You get 15, 20 pages of text sometimes, whereas with design patents, it's really just the drawings that you're doing. So zooming in on what the design patent drawings look like, they're actually more detailed. We have to have a shading on every surface. Notice also that where it says here in Figure 3, ABC store, that is done in what we call broken lines. And so it's optional. It's not really there. It's not considered part of the claim. When you put something in broken lines, like your logo or something that's not something that a competitor is going to copy, then you're disclaiming that element from the design patent. So a design patent really is protecting only those things that are in solid lines, just if you're looking at them. Now compare that to a utility patent drawing. This is, we're showing inside of it how it works. We have a couple of springs, a couple of spherical marbles or balls that push outwardly. And we're going into all that detail in a utility patent. Also, there's all these numeric callouts. You don't have that on a design patent. So let's get into some of the pros and cons of design patents. For one thing, like I mentioned earlier, they're less expensive. And I'm just going kind of by our pricing, but you can, look out to other firms and see what they charge. A design patent from start to finish is about $1,500 for 15 years of protection. That's $100 a year. So I think I think design patents are underutilized because there's a lot of bang for the buck there, especially when there's not that much buck. I think that a lot of times people they'll put a lot of money into their utility patent, which might be fine, but don't think of it as an either or. I like the idea, if you have something that is suitable for a design patent, I like the idea of using design patent as well. And we'll get into some more reasons why that's good. Because they're so inexpensive, it's easier to add patents to your patent portfolio. If you just have one patent, that may be okay, but it's more impressive if you have a patent portfolio. Stephen's experience with Fishbone, I mean, we're getting a lot of IP there, and a lot of those are design patents, but it builds out a big list of patents. And that can be very ominous for a competitor who's thinking about, maybe I should compete with these guys. Well, if they have a whole list of patents that they're going to go up against, that should give them more pause than just if it was one patent. Another advantage of the design patent is that it goes through the patent office more quickly. So if you've had experience with utility patents, it could be 1.5 to 2 years, 3 years. If you're in a field like computer software or business methods, it can be even longer than 3 years. And that's a long time to be patent pending. You just don't know what your protection is going to be. Whereas with the design patent, it's usually about 1 year to 1.5 years. It's easier for the patent office to examine design patents, and so they're able to burn through them more quickly. There's also fewer of them filed every year. So what you may get is, if you file both a utility and a design patent on the same item at the same time, or roughly at the same time, it's probably going to be the design patent that gets issued first. And so that would represent the first arrow in your quiver that you can shoot at a competitor if it's, if they're getting too close to the way your product looks. You can also speed up design patents just like you can utility patents through the patent office. The program that speeds up design patent at the patent office is called the Rocket Docket program, and they try to get to it within 2 to 6 months. And you do have to pay more to the patent office to do that, but it might be worth it if you're in an area where there's a lot of competition and you're going to get knocked off quickly. You want to get your patent in your hand as soon as possible. So that may be worth the extra expense. Here's an example of a Rocket Docket design patent that we had issued. Notice the filing date here is January 31st, 2019, and the issue date is July 9th, 2019. So what's that? Just over 6 months. That's like top speed for the government. I mean, that's pretty impressive. So the Rocket Docket system does work if you're in a pinch and you need to get a patent issued quickly. Another huge advantage of the design patent is that you're probably not going to have an office action like you get with utility patents. 95% of the design patents are just allowed straight away. We don't have lots of issues with prior art. I mean, 5% of the time we do, and then that's a separate issue and how we have to deal with that. We have to respond just like we would on a utility patent. But with utility patents, it's really the opposite. 95% of the time, they're rejected. And then you got to argue with the patent office. And ultimately, somewhere between 60 and 65% of the time, you can eventually get the utility patent issued. Those are just nationwide statistics. But with design patents, it's 95%. So it's much more of a sure bet. And if your licensing agreement says, that you're going to get one royalty if you have something that's patented and another royalty lower if it doesn't get patented, or you have some kind of language in there that gives you an incentive to get a patent, a design patent might count. Now I'm not suggesting that you be dishonest in what kind of filings you've done, but the design patent can help with licensing agreements if they're worded in a particular way. The other thing about design patents is you can say patent pending. You don't have to say design patent pending, you just say patent pending. And sometimes just being able to say patent pending is what opens doors. Now, it's important to remember what patent pending means. The way I like to think of patent pending is it's like a big no trespassing sign on a piece of property that you don't own yet, okay? And so if you've filed a utility patent and a design patent, now you can legally say multiple patents pending, right? It's a little bigger no trespassing sign. And so people ask me all the time, does that give me any rights? No, it's like a no trespassing sign, but you don't own the property. If somebody starts to copy you and they set up a lemonade stand on this property, you won't be able to legally evict them until you own the deed to the property. Okay, so that's the way I think of patent pending and when you get your patent issued. And if you're in a competitive industry, you might want to do everything you can to get those patents issued more quickly. Now, the drawback of design patents is that they're not as compelling to licensees. A lot of licensees haven't gotten the memo from the 2008 Supreme Court decision called Egyptian Goddess, which strengthened design patents. A lot of licensees and a lot of business people in general will say, well, design patents are easy to design around. That may be true, depending on what the geometry of your product is. But if there's distinctive qualities about the way your product looks, and particularly if those distinctive qualities make it so that it can work in a certain way, that can be a strong design patent. And the 2008 Egyptian Goddess decision changed the way they test for infringement in court. They're now using the ordinary observer test. And so I'm going to show you some examples of how that works in court. And like I said before, the design patent doesn't protect the way it functions, it just protects the way it looks. So you can't even use design patents on things like software methods or apps for your phone or chemical patents. It doesn't apply. So if you have a tangible product, it's certainly worth looking at to see if a design patent would be an option, but it's not always an option. So here's an example of a case where the ordinary observer test really helped. You can see, everyone's familiar with Crocs sandals, I'm sure. On the left, we have the design patent drawings. And on the right are examples of counterfeit products that a Chinese importer was bringing in. And you'll notice that these are not exact copies of what the design patent shows. The holes have a different shape. They make a different pattern on the front of the sandal. The strap going around the back of the ankle is different. But when the judge looked at these and compared them, he said, the average consumer, the ordinary observer, is going to look at these and think that these are Crocs. And so they were able to prevail in that case. Another very famous example is Apple versus Samsung. Apple won, I think the judgment was $500 million from Samsung for infringing the Apple design patents on the iPhone and the iPad. And the thing to note here is that the broken lines in the Apple design patent drawings disclaim certain elements. And so the only thing that's claimed on these patents, and there's about 4 of them that protect different things, but the only thing that is claimed are those things that are in solid lines. So even though the Samsung Galaxy doesn't have the round hole, it had I think it was like an oval hole, or not a hole, but a button. You know, the court still found them infringing those design patents. So real quick, I want to run through what a good design patent looks like, so that when you're getting a design patent application from your practitioner, you can have a sense of what what should be included. Design patents typically need 7 views. They need all 6 sides of the object. So here's a pair of jeans that we did a while back. Figure 3 here is the front view. Figure 4 is the rear view. So front, back. This is, believe it or not, the left side. And that's how the patent office wants you to call that. They call that the left side. It's not as though you're wearing the pants that determines that. It's when you're looking at the front view, which side is on the left and which side is on the right. Go figure, it's the government. But that's the left side view. Then figure 6 is the right side view. And then you have a top view and a bottom view. So you have all 6 sides. And then they also want a perspective view. Many people call it an isometric.
So I was a little surprised by what Bortnikov said.
Oh, someone's coming in.
That, you know, he's toting extra hard.
The perspective view is from an angle. And I like to show perspective views in use if possible. So you'll notice that we have the person who's wearing the jeans in broken lines. We're not claiming that she's part of the design. And then we also had a figure 2. In this case, we had a different configuration where you can take the legs off and turn those into shorts. Here's another example of a patent that we did, has different configurations. A duck decoy. We had a floating position and a submerged position. So sometimes it's important to show those different configurations. We can also, and this is something that a lot of people don't realize, is we can file a single design patent with multiple embodiments.
Find a way to be together.
So in this example here, we argued to the patent office that this is the same design, that these are just 2 different embodiments. And if you're trying to figure out where the difference is, it's down here in this bottom panel. And so those are close enough that the patent office gave it to us. Sometimes they don't. Sometimes they say, well, those are really 2 different designs, and you got to pick one, and then you got to file what's called a divisional application on the second one. But if they're close enough, then you can get protection on multiple variations just with one patent. So that saves you money. If the patent office lets it through on the same application and grants it on the same patent, then you're in luck. Now, here's the text part of a design patent. It's really quick. There's basically 2 things. There's the title, and a lot of people want to put their trademark in the title, and that's a no-no. The title has to be a boring, descriptive title. It's not something that is a trademark or a brand name. So you wouldn't say Whiz Bang 5000 in your title. You would say, you know, Weed Whacker or something like that. And then you have the description of the drawings, and this is basic. You can't really do much variation here. If it's a perspective view, you got to call it a perspective view, and so on. You just describe each of those views so that the patent office knows what you're talking about. And then if there's a broken line, you have to explain what that broken line represents. And then there is a claim in a design patent, but it's a single claim, and the wording is fixed by the patent office. It's we, depending on if there's co-inventors or not, claim the ornamental design for A, and that's where you put the title of the invention, as shown and described. That's it. So it's very simple. And I'm just going to go through a few examples, noteworthy examples of design patents. These are kind of fun. And I love the design. I love the artwork on design patents. So this one, everyone should recognize. This was a gift from France, but they put a patent on it anyway. Back then, you only needed one figure to show in the design patent. So this was back in 1879. Design patent 11023. Here's one that shows how you can, with shading, you can do some really neat contour effects. And that's one of the things about design patents. Every surface has to have some kind of contour shading, so you know if it's flat or concave or convex, or how the contours look. And so this is just line art drawing, but I think it's a beautiful example. Here's one that a lot of people will recognize from Disney. This is the Dumbo ride at Disneyland. That's just one of the views. And I like this example because it shows what's called oblique shading. So this 45-degree shading here on the glass cover indicates that it's a transparent cover. So anything that's transparent has to have this oblique shading. And of course, you can see through it. This is a different kind of shading. It's called stippling, and it looks nice. I mean, that looks beautiful, but it is difficult to update if the patent office wants to make any changes. And sometimes they'll come back and say, we don't like the shading on this surface, or it doesn't match figure 3 or whatever. And so if you have to update your drawings, it's best not to have stippling, because that can take a long time to fix. There are some times, and you'd think that we'd be in the 22nd century here already in the patent office, right? They like line art drawings. They don't like photos or renderings. And so, they try to encourage us as practitioners to use line art drawing. There are some cases where you just can't show the shading appropriately. This is a gold nugget hat we did for the, the Gold Nugget Casino. And it is a gold color, but that doesn't show through in the design patent, because you don't want to limit it yourself to gold color if you don't have to. I mean, if this was green, they would still be protected. So, but anyway, this shows kind of the contours of this gold nugget. I mean, I've never seen anyone wear this hat, so I don't know how successful it was, but there are some situations too where color is important. And this was a case where we had a hard time getting it through. We finally converted it to color drawings, and that seemed to do the trick. But the patent office doesn't like color. You have to file a separate petition and get permission basically to use color. What they'd rather see is, like in this example, we have a fence stake, and the top part of this you'll see is shaded. It has like this particular vertical line shading. Well, that vertical line shading represents the color purple. And in this case, this stake is where if you have reclaimed water lines running along the fence, you're letting people know that's reclaimed water. It's not potable water. So you have to have that kind of light purple color on the stakes. And so basically this inventor killed two birds with one stone. And in the Guide to Filing Design Patent Applications produced by the PTO, they give you some of the different shading patterns to use for the different colors. Here's just some other examples of things that I thought were noteworthy. We did the design patents for the Squatty Potty. Judy Edwards, she's done real well with the Squatty Potty invention, and we did her design patents for that. This was another product that was on Shark Tank. It was the Cool Box, which is a toolbox combined with a Bluetooth radio speaker or Bluetooth speaker. I don't know. I don't think they did a deal, but they did get some notoriety. And this is just an example. This is from 1875. And you'd think with computers and everything that we'd be able to do some really beautiful drawings, but you just don't see them like this anymore. I can't imagine how long this took. And the artists were at the time, the artists on the patents are anonymous. You don't know who the draftsman is. So somebody spent a lot of time on this, turned out beautiful. Here's another one that it's just gorgeous how they did that. In fact, I came across so many of these. I was doing, I don't know, maybe 3 or 4 patent searches a day at one point. I was coming across so many beautiful patents. I went ahead and put them in a book called The Art of the Patent. And we did a Kickstarter on it, and it was successful. So that was a fun project. And then later on, actually, just to show my kids how to do this, I did a bunch of playing cards. Each of the playing cards has a patent drawing on it. And it's public, you know, it's fair use. So I didn't have to pay anyone royalties for the drawings, which was nice. All right, so that is it. That is a very quick intro. And if anyone has questions, maybe
Yeah,
someone
Kevin,
can jump
let's
in
do
and
this.
feed them to me.
Yeah, take off if you would stop sharing too. Thank you very much, Kevin. Wonderful. There's a million questions. Okay, so what I like to do is ask some of these questions. Hey, Kevin, here's the big question here. All right, I get a design patent, but someone changes it just a little bit, right? So what happens with that? I'm always a little confused. How much can they change it and that they would potentially get around what I have?
Right, so there is a point at which they can change it enough to get around your design patent. The question is, where is that point? And in 2008, that Egyptian goddess case, it made the point further away. I mean, the average consumer, if they're confused about who's making this product because it looks similar to yours, you probably have a good case.
Got it.
It has to be different enough so that the average consumer doesn't think it's the same product.
Okay. So what are the fees? You gave us your fees. Thank you very much for doing that. What are the fees, the average fees? What about the USPTO? What do they charge? And are there maintenance fees to this too? And how long do I have a design patent for?
Yeah, so the design patent term is 15 years from the issue date, which is different from the utility patent. Utility patent is 20 years from the filing date, and plus or minus some extra time they might give you if they take a long time. So the utility patent side is confusing. Design patents are easy, 15 years from the date it issues. Okay, the filing fees for micro entities are $204. For small entities, it's $408. And if you're a micro entity and small entity, it's kind of confusing. You're a micro entity if you've filed fewer than 5 patents in your lifetime, and you made less than 3 times the median household income last year, which comes out to like 223,000 and change. Okay. So if you're under those numbers, then you're paying the lowest fee at the patent office. You're a micro entity. So
what about no maintenance fees?
There's no maintenance fees on it. Now, don't jinx it by talking about it. We don't. But no, there are no maintenance fees on design patents.
Okay.
And that can be several $1,000s with utility patents.
Well, yeah, the utility, those can get real expensive if it's year number 11, right?
Oh, yeah. It can be $3,600 for the 11 and a half year filing fee. Sure.
Okay. Someone asked this question. I know things do change, but I'm selling my product on Amazon. Okay. And they typically not only do they knock my product off, they knock my image. They take my picture. They take my logo. They take my trademark. Man, they take everything there. They just copy everything. In fact, they take everything I've done and just take it over and they sell it themselves.
Right.
I know
copyright. And there's 50 of them. There's 50 guys doing that to you.
Yes. So yeah. How helpful is a design patent?
Oh, it can be really helpful especially if they're verbatim copying you.
Okay.
Then they're going to be copying exactly what you're doing, right? So there's no question that they're infringing your design patent. There are attorneys that, in fact, one guy in LA, he does what he calls Amazon law, and that's his favorite scenario. You have a US inventor with a design patent or a utility patent or both. 50 competitors have jumped on, all from factories in China. And what he does is he gets an injunction and he locks up all their funds, and then they just go away. And so there are ways to do that, but you do have to have some kind of a patent if you're going to protect the product itself. If someone's just copying your images and your wording, that's a copyright issue.
Okay.
And if they copy your trademark, that's a trademark issue. So you
So-
might get them on all three of those.
So let's talk about let's talk about public disclosure for a minute. I've got my product. I've been making it. I've been showing it for a while, but not quite a year yet. Can I still file a design patent?
Yes, you have 1 year grace period in the United States and a handful of other countries. Now, a lot of countries like China don't have a grace period. So if you publicly disclose your product, you start selling it, or like what happened to my cousin, he had a product that was selling great in California. It was a firearms product. And so I think in week 50, we filed a patent for him. And he didn't realize that one of his beta testers had taken a video of how to assemble this on a firearm and uploaded it to YouTube. And the patent office found it. And that was more than a year before our filing date. And so we were out of luck. There's no way to get that patent. So you do want to be careful about the timing on these things. If you care about foreign patents at all, keep it a secret until you file your patents, both utility and design, if you're going to do both. If you don't care about foreign patents, you can launch the product and see if it's going to work in the marketplace, right? But I wouldn't dilly-dally filing your patents because we're on a first-to-file system now.
I know.
So you do not want to be second in line at the patent office.
No,
you don't get anything if you're second in line.
Yeah, let me, you guys, just so we're clear, I file my own provisional patent applications. I file my own trademarks, copyrights. I do all that. I don't file my own design patents. Okay. I
wouldn't either, because you've got to have really good drawings, and so you need a draftsman who knows what they're doing. Yeah.
No, it's more complicated than it looks. Okay. So that's why I wanted Kevin to come on, because I'm pretty comfortable doing all of it. I won't do that part because I'm going to do it wrong, and I have done it wrong, and it kicks back, and then I got to call Kevin in. I'd rather just call him at the very beginning and take care of it.
And the scary thing is you can have filed fatally flawed drawings. I mean, there may be no way to save it if it's not done the right way. I've seen that, and I got to tell the bad news. I'm sorry, we can't save this. You didn't have this view in your original file,
Okay, let's talk about this. I've got an IP strategy here. I want to file a utility and I want to file a design patent. Do I do one before the other? Does one impact the other?
They're completely separate tracks. So
okay.
If the easiest one to file is the design patent, we can get that done in a week or two. Utility patents take longer because of all the wording. So if you're starting today, we can probably file your design patent first, and then a few weeks later file your utility patent.
Okay.
But if you've already filed your utility patent and now you're thinking about following it up with a design patent, all those grace period and all those time periods are still in play. That's just they're separate for each type of patent.
So, Kevin, here's a big question. Now, I'm up here in Lake Tahoe. Do I have to visit you in Las Vegas? I mean, that seems ridiculous now. And I know a lot of us want to be really close to our patent agent or patent attorney. Is that even, why do people even care anymore? Or do they? Or should they?
Don't you want to come to Vegas?
Well, no. Well, yes, I do. But
okay, so no, the answer is no. We can do it right here on Zoom. You can send me the CAD drawings, the photos that we need. I have clients in every state, so you don't have to come visit me, even though that may be attractive.
I know for some reason, a lot of us think that we have to, I've been filing patents for a long, long time. I think I visited my patent attorney one time and I realized I never want to do that again. I want to be short to the point and send them an email. That's what I want to do because I end up talking too much.
Yeah. And we started, and they'll bill you too.
Yeah.
We started in Orange County, California. That's where I was raised. And that's a very innovative area. And I thought, can we really move out of here? But it's been fine. I mean, I can do anything over email, phone, Zoom.
Okay, before we get to the groups, I'm going to make it really quick. Now you're a patent agent. Now, maybe I want a patent attorney. What's the difference between the two?
So both patent agents, like myself, and patent attorneys have a 4-year science or engineering degree. So I have an engineering degree out of Berkeley.
Berkeley.
Berkeley, yeah. Okay, and a patent attorney additionally has a law degree. And so the way it's set up, the intent of Congress when they created patent agents was that I could represent clients to the patent office just like an attorney. I can do everything that an attorney can do at the patent office with regard to patents. I just can't take it beyond the patent office in the court and sue somebody for infringement or write a cease and desist letter or even do trademarks. They don't let me do trademarks. They consider that the practice of law. So I can just do two things. I can do patent searches and write patent applications and get them through the patent office.
Kevin, thank you very much for coming on. Hey, I love all the tools that you're going to need to protect your inventions. Design patents is just one tool you're going to need, because at the end of the day, when you're negotiating with these big ass companies, you need an intellectual property strategy, and design patents are just one tool. I'm going to be talking about all the other tools that you're going to need when you're negotiating with these big ass companies. If you have any more questions, do not hesitate to reach out to me, Stephen at patentyourinventions.com. And here's my channel up here. And if you want to watch more videos, please click here.